Well, hi there. Welcome back to Professor Snyder's. It's me, Music Biz News. Anybody who was around in the 1980s definitely can remember the song Push It Real Good by Salt-N-Pepa. And you might be surprised to find that you can't find that song on any of the streaming networks like Spotify. And that's because their record label, Universal Music Group, has taken it all down. Cheryl Salt James and Sandra Peppa Denton say they are being punished by Universal Music Group, that they are holding their other songs, Push It and their other songs, hostage. The stunning act of retaliation by the record label is because Salt-N-Pepa are trying to regain the rights to their music, to their recordings from the record label. Right now, the record label owns the recordings, and so only the record label can license out the recordings and collect royalties for the recordings. The suit estimates that the catalog has generated $1 million in the past 5 months in sync licenses alone. And sync licenses would be commercials and video and movies and things like that. So the ladies want to do the licensing on their own and make all that money themselves instead of just getting a portion of it. They claim that UMG is impeding their right to promote and make money off the recordings themselves. Or, more likely, like Pink Floyd and Sting and Bob Dylan, they want to get all the rights to their recordings back so that they can turn around and sell their catalogs for millions of dollars, which is the big trend right now. The lawsuit comes just months before Salt-N-Pepa is due to become the second ever female hip-hop act to be inducted into the Rock and Roll Hall of Fame this November. The group's legal reps say in a statement, "This fight is about more than contracts. It's about legacy, justice, and the future of artist ownership, but it's really about the money." We all know that. Now, first of all, Salt-N-Pepa are the recording artist. They didn't write the songs. The song, like Push It, was written by Ray Davies of the Kinks and Herbie Lovebug Azor, who seems to be the writer on a lot of the Salt-N-Pepa songs. The ladies didn't write the songs. They are the recording artist. And the songwriting copyrights is a totally different topic, so I'm not going to go into that. I'm just sticking with recording artist. According to copyright law, Section 203 of the Copyright Act permits authors, or if the authors are not alive, their surviving spouses, children, grandchildren, executors, administrators, personal representatives, or trustees, to terminate grants of copyright assignments and licenses that were made on or after January 1st, 1978, when certain conditions have been met. Termination of a grant cannot be effective, and termination of a grant is what Salt-N-Pepa are attempting to do. Termination of a grant cannot be effective until 35 years after the execution of the grant. In other words, when the record is actually released. Salt-N-Pepa are accusing the label of violating the Copyright Act by not allowing the musicians themselves to reclaim control of their music's intellectual property 35 years after its release, like copyright law says they can. And to make a reverting back to them as the owners, the author will need to file for copyright termination within 5 years prior to the 35-year expiration date. Salt-N-Pepa did this. Salt-N-Pepa served UMG with a notice of termination rights in 2022, claiming its albums, Hot, Cool, and Vicious of 1986 and A Salt with a Deadly Peppa of 1988 were both up for copyright termination in 2024, so they met that 5-year requirement. But UMG allegedly rejected Salt-N-Pepa's notice as invalid and ineffective, claiming termination rights do not apply because the albums were works made for hire. Okay, and looking back at copyright law, according to copyright law, termination rights under Section 203 do have their limits. First, they only apply to works other than a work made for hire. Therefore, works made for an employer by an employee within the scope of their employment are not subject to termination rights. And Universal Music Group is saying that Salt-N-Pepa were employees of the record label and not independent artists, which is what Salt-N-Pepa are claiming to be. Salt-N-Pepa's lawyers say that contrary to what UMG is claiming, nothing in the duo's original contracts with the record labels defined its music as works made for hire. And this was something I wasn't aware of. It's important to note that federal courts have rejected agreements entered into after a work was created to retroactively deem the work a work for hire. Such agreements are considered to fall under Section 203's prohibition against agreements to the contrary of the statutory termination rights. This underscores the importance of entering into work for hire agreements before the works are created. In other words, if somebody has contracted you to create artwork or video or animation or music, and there's a contract, and if in that contract they don't designate your work as being work for hire, in other words, that they're paying you to create this stuff, that you are basically an employee, if it doesn't stipulate that, they can't go back later and say, oh, but this was work for hire. It has to say that in the contract. If it doesn't say it in the contract, you most likely still have ownership of whatever it is that you created, unless you were officially an employee of the company, then you are definitely work for hire. But if you're an independent creator, this is something to consider. And if you are hiring somebody to create some work, you must let them know up front in the contract that it's work for hire, and they have no expectations of any claims of copyright in the future. So do Salt-N-Pepa have a case? To drive them to the negotiating table and for hopefully a cash settlement of some type, Universal Music Group pulled all of their music off of the streamers like Spotify so that nobody can call it up. And so because of that, Salt-N-Pepa is suing them for an additional $1 million in damages because UMG is willing to sacrifice all of those streaming royalties, which of course that means also Salt-N-Pepa are not getting streaming royalties as well. And this is right before they are going to be, accepted into the Rock and Roll Hall of Fame. So that is the time you definitely want to have your music up on the streaming network so that people hear about you're getting this recognition, and so they go looking for your music. And if they can't find it, you've lost money. That is why they're suing for the extra $1 million. So hope you enjoyed this episode. Please like and share, subscribe, all that kind of stuff. Thanks for watching.